Hello and welcome back to my channel. There is some things to get into. Wow, within the last 24 hours, a lot have happened in the court of It Ends With Us, and I am here to talk about all of it. Was there a win for Justin Baldoni and the Wayfarer people? Did Blake Lively get a little slap on the wrist? What's going to happen next? Oh my gosh, the last 24 hours, very interesting, and we're going to get into all of it right now. So if you're ready, I'm ready. Grab your emotional lip gloss. We are going straight in because the gaslighting, the lies, the manipulation, finally the judge has put a stop to it. And hopefully this is a sign to Blake Lively and her team that enough is enough already. Let's go. You're in frame with Mandy Magnan. Last night it was filed in the courts by the Wayfarer party, Mr. Brian Freeman, and the lawyers for the Wayfarer parties, a letter motion to compel Blake Lively to produce medical records as well and or at least withdraw the claims that they say in writing. Blake Lively said that she was withdrawing her 10th and 11th cause of action for emotional distress and infliction of that stress. They were looking for general health information that is highly relevant to Miss Lively's cause of action, which is her 10th cause of action is intentional infliction of emotional distress, and her 11th cause of action is negligent infliction of emotional distress. Then we find out that in writing, Blake Lively is actually voluntarily going to withdraw those causes. So instead of show her medical records, she's going to withdraw those causes, but she wants it without prejudice. Well, the Wayfarer people were like, no, you can't have it both ways. Either you're going to withdraw this, which is what you said, with prejudice, meaning you cannot refile after discovery or whenever you feel like it, whenever the moment hits you in 6 months, a year, whatever it be. You're not allowed to refile. Either you do this now while we are here or never again. So either one, produce your medical records, or two, withdraw the claims that she says that she's already said that she voluntarily wants to do, and she just did that in writing, but wants a stipulation without prejudice, which is like so already bananas. Because when you get to this point of the lawsuit, girl, you better be ready to fight. Fight for your rights. Fight for what happened to you. Be ready. Oh, you want my medical records? Here you go. This is what you did to me. I have nothing to hide. Look at it all. Look what you did. This is not uncommon in any lawsuit where you are suing or you are alleging emotional distress or infliction of emotional distress. You're gonna have to show your medical records, okay? If you get into a car accident, for example, and you go and sue the insurance company or the other person driving, and then it turns out it's the insurance company did, do you know how many doctors you got to go to? How many people you need to see? When you're suing a toxic work environment, you better be able to show that because of that toxic work environment, you incurred a lot of damages and that you had to seek professional medical help. This is not new. This is very, very standard. So she doesn't want to do either. She wants to withdraw the claims, but have it without prejudice. And then she also, doesn't want to show medical records. It was bonkers to read this letter, honestly, that the Wayfarer people drafted last night. But I knew this morning we were going to wake up to a little gaslighting and a bunch of things from the Lively people who always run to the press first, and they did not fail. That is exactly what happened. And of course, the first ones I checked was People, because we know that that's where Blake Lively's team likes to go. Blake Lively's team runs to the media immediately. And what I find so funny and kind of hilarious, and now I do in a way feel bad for Blake, but then I remember all the monstrous things she's done, and that feeling dissipates quite quickly. But I knew that her people were going to run to people. They run to people all the time. Blake Lively her team literally is projecting everything that they do. They say the Wayfarer people have done. And this whole running to the media, they're just doing it for a media circus. It's old, it's tired. You're using the same excuse while everyone knows that you have been using the media since day one. This whole year of 2025, all Blake Lively and Ryan Reynolds have done is use the media, be out and about, doing all of these things, like going on and on about them. Like, enough. Just enough. I think that's going to be the word today for this case. Enough is enough. But of course, Blake's lawyers did have something to say to people. And as we do here, let the gaslighting begin in 3, 2, 1. Lively's lawyers, Edra Hudson and Mike Gottlieb, responded to a statement shared with People. Once again, this is a routine part of the litigation process that is being used as a press stunt. We are doing what trial lawyers do, preparing our case for trial by streamlining and focusing it. They are doing what they do, desperately seeking another tired round of tabloid coverage. The Gossip Girl actress continues to allege emotional distress as part of numerous other claims in her lawsuit, such as sexual harassment and retaliation, and massive additional compensatory damages on all of her claims. So again, they're saying, Brian Friedman, he just filed this just to run to the tabloids. It's another media circus. You know what Brian Friedman isn't doing? Running to the tabloids every time something happens. You know what he is doing? He's filing in the court. He didn't run to the tabloids in the media. Actually, how this all started was Blake Lively using the media when she made that story in the New York Times and gave it to them. Yeah, it's just old, it's tiring. It's just such a lame excuse at this point. Anything that the Wayfarer people do, anything that they say or do, this is the response from the Lively people. Oh, they're just doing that for media attention. Oh, it's just for the news. Come on, they're defending themselves and fighting a case, okay? And if you are still fighting your claims, show your medical records, proof that this happened to you. Obviously, this says that either 1, there's nothing, or 2, there's a lot there that have really nothing to do with probably It Ends With Us and Justin Baldoni. And what I find super cringe and hypocritical and absolutely just the audacity, if I'm actually being honest, is that Blake Lively disclosed not only Justin Baldoni's medical records, but also Jed Wallace's, which were supposed to be attorney eyes only. She had no problem disclosing other people's medical notes, but then when it comes to her own to prove her case, this should strengthen her case. No. But even in Blake Lively's lawsuit, when she wrote this about Justin Baldoni, a private text message between Justin Baldoni and Jennifer Abel, she put into her lawsuit about how he wants to go on the Dr. MN show and talk about his neurodivergence. She put that in her lawsuit. And I feel like an illegally obtained text message, but she had no problem leaking Justin Baldoni's private text message about his medical history and his personality. I don't want to say disorder, but yeah. And then again with Jed Wallace's lawsuit, it was again attorney eyes only and privilege in the New York. And then when she filed in Texas, she disclosed his personal medical information. And they wrote even here in their amended lawsuit against Blake Lively in court, it says worse than the economic toll is the assault on Wallace's emotional condition. Lively has blasted out in court filings, in this case, confidential health information about Wallace, despite this information being sealed in the New York case and in a redacted declaration and in letters marked confidential. Wallace has suffered medical issues induced by Lively's actions. Wallace's stress began December 20th, 2024, when plaintiff's world turned upside down from the maliciously leaked CRD complaint and the draft complaint, which made totally false and fabricated allegations against plaintiffs, Jed Wallace, and his company. Such physical manifestations are the strongest evidence of mental anguish damages. So, no problem disclosing private text messages between Justin Baldoni and his PR team, Jennifer Abel, about his medical condition. No problem releasing sealed medical information about Jed Wallace. But when it comes to her giving over her medical information to prove her case, no, not doing it, withdrawing the claim. Something weird is going on, but this is just tells me everything I need to know about the type of people they are, because the audacity, it's shameful, so shameful. It's like, just so gross at this point. But Brian Freeman and his team are working, okay? They are eating in the courts. The documents that were filed just today, eating. Do you remember the sanctions? Remember when she filed the Rule 11 sanctions, which everyone was like, whoa. And I mean everyone from me all the way up until lawyers were like, whoa, sanctions Rule 11 is like the strongest, the last resort. Like, you don't use it here, especially when you already filed a motion to dismiss. Now she wants sanctions on the Wayfarer people. She's filed so many things in the court that, in my opinion, are abuse of the court, honestly. Like, even now we know with the advocacy firms, if you haven't watched that video, how they're all tied in. Blake Lively's lawyer sits on the board of directors of those advocacy firms. I mean, it's just like, wowzers. But you know what? Brian Freeman, he's clocked in. He is clocked in, and we're going to get to those right now. This is a consolidated plaintiff's opposition to consolidated defendant Blake Lively's motion for Rule 11 sanctions against Jamie Heath, Steve Sauritz, Melissa Nathan, Jennifer Abel, It Ends With Us Movie LLC, and their counsel. Do you remember in the motion for Rule 11 and for the sanctions, Blake Lively asked for lawyers' fees to get paid, as well as charges, sanctions against the Wayfarer people, as well as their lawyers for filing frivolous claims and abusing the court dockets and the time on the court. This is the response from the Wayfarer people to that Rule 11. Introduction. Consolidated defendants Blake Lively's Rule 11 motion, the motion, seeks sanctions against individual Wayfarer parties, all of the parties. Ironically, the motion itself borders on frivolous, as it contravenes Rule 11's 1993 advisory notes, and unanimous authority governing Rule 11 sanctions, which teach that Rule 11 motion should not be employed as a discovery device or to test the legal sufficiencies or efficiencies of allegations in the pleadings. Other motions are available for those purposes. Thus, Rule 11 should not be confused with Rule 12b motion to dismiss, which is what they already filed, for failure to state a claim for relief, and a Rule 11 motion based on a deficiency in the pleadings is improperly, particularly where, as here, it is based on arguments substantially identical to those made in support of a motion to dismiss for failure to state a claim. Lively's motion is cynically silent at this point, even though it was conveyed to Lively in plaintiff's response to Lively's Rule 11 safe harbor letters, which she sent to everybody. Lively similarly fails to note that she has filed a Rule 12b motion to dismiss, raising pleading defects that are substantially the same as those that are in the heart of her Rule 11 motion. And then in the footnotes here, it says, Lively admits that her motion is based on an amendable pleading defects. Therefore, they can re-amend it. They can amend any of the things that she's having issues with. So if it's amendable, there's no need for this sanction, right? Rule 11 is not a vehicle to challenge pleading deficiencies that are or should be the subject of a Rule 12b motion to dismiss, or an avenue to obtain an early determination on the merits. In fact, giving the plain import of the advisory notes and relevant case law, Lively's motion is nothing more than a transparent effort to tarnish the Wayfarer parties and their counsel in the eyes of the court and the press. Exactly the type of conduct that Rule 11 is designed to discourage. As shown below, the advisory notes to Rule 11 and relevant authority preclude Lively's request for sanctions. Factual background. On April 23, 2025, Lively directed 6 safe harbor letters threatening plaintiffs Heath, Starrett, Nathan, Abel, and It Ends With You and their counsel. So remember, she sent these letters to everyone except Justin Baldoni and their counsel with Rule 11 sanctions, collectively the letters, on the ground that the complaint fails to adequately plead claims for extortion, interference with contract, prospective economic relations, and breach of the implied covenant of good faith and fair dealing on behalf of individual plaintiffs grouped into the definition of the Wayfarer parties. In a consolidated response, the Wayfarer parties explained to Lively that Rule 11 does not apply to pleading defects that were or were more properly raised in Rule 12b motion to dismiss. Undeterred, Lively has now filed a Rule 11 motion based on perceived pleading defects that were raised or could have been raised in her pleading Rule 12b motion to dismiss. To wit, and then they say the reasons why. So the complaint fails to allege that Lively made extortionate threats to Soritz, Nathan, Abel, and It Ends With Us, or deprive them of anything, and thus fails to state a claim for extortion against them. The complaint fails to allege that Heath, Saritz, Nathan, and Abel were parties to a contractual or economic relationship with WME, and thus fails to state a viable interference claims against them. 3. The complaint fails to allege that Heath, Soritz, Nathan, and Abel were parties to any contract that is the basis of the Wayfarer's claim for breach of the implied covenant of good faith and fair dealing. What I find interesting is Jed Wallace also said that to Blake Lively in his original lawsuit, is like, hey, you group me in with all of these people in the New York Times article saying that I'm sexually harassed you and then covered it up with a smear campaign, and you grouped me in there. And then Blake Lively came and was like, whoa, we only said your name 6 times in our CRD complaint, and you should know what you did and how we named you, and that has, that was just for the smear campaign. But now it's like the Wayfarer people are all grouped together, and Blake Lively's like, whoa, because you didn't individually name each cause, I want it dismissed, as well as now I want sanctions. Like, she's playing each court so differently. Like, it just shocks me the way this is going and how they're able to get away with these things. But Lively's Rule 11 motion subverts the very purpose of Rule 11 by impermissibly confusing Rule 11 sanctions with the Rule 12b motion to dismiss. Rule 11 sanctions are not available for perceived pleadings deficiencies, which can be challenged by a Rule 12b motion to dismiss. Rule 11 applies to pleadings and other papers filed with the district court, which certify that, to the best of his knowledge, information, and belief formed after an inquiry, reasonable under the circumstances. The claims, defenses, and other legal contentions are warranted by existing law or by a non-frivolous argument for extending, modifying, or reversing existing law, or for establishing new law. Lively ignores and asks this court to ignore the advisory notes to Rule 11, which explicitly state that Rule 11 motions should not be employed as a discovery device or to test the legal sufficiencies or efficiency of allegations in the pleadings. Other motions are available for those purposes. Notes: courts uniformly hold that Rule 11 should not be used to raise issues of legal sufficiency that more properly can be disposed of by a motion to dismiss, a motion for a more definite statement, or a motion for summary of judgment. As a general matter, dismissal of a frivolous case on the merits should be a first option, whereas imposition of sanctions should be a matter of last resort. Right? Like, last resort, girl. It is well settled that Rule 11 should not be used to raise issues of legal sufficiency that more properly can be disposed of by a motion to dismiss, a motion for a more definite statement, or a motion for summary judgment. Thus, a motion for Rule 11 sanctions is improper, whereas here it is substantially identical to the arguments made by defendants in support of their motion to dismiss for failure to state a claim. A Rule 11 motion should not be used as a substitute to a Rule 12b motion to dismiss or to obtain decisions on the merits at an early juncture of the litigation. Essentially, the defendants are asking the court to award sanctions because they believe the merits of their defense. However, resolving the defendants' arguments will require the court to make a factual determination regarding a claim essential to the merits of the action, an issue for which Rule 11 motion is an inappropriate vehicle. To allow for good faith belief that reasonable investigation and discovery will uncover additional evidence to support the claims. Then they go into some rules and other rulings from that motion. Then it gets very juicy. Okay. Lively seeks sanctions for pleading deficiencies she has already attacked or could have attacked in her pending motion to dismiss. Purported pleading defects, particularly those already before the court in a pending motion to dismiss, are not a proper subject of a Rule 11 motion and fall far short of the righteous test defining extraordinary misconduct worthy of Rule 11 sanctions. This is what I found interesting. Lively is not entitled to an early dispositive decision on the merits without discovery of her extensive factual arguments. Under the guise of a Rule 11 motion and the fact that Lively believes she will prevail or deems any allegation against her as harassing is insufficient to justify Rule 11 sanctions. Discovery is still in its infancy, and Rule 11 is not a mechanism for an early disposition that would cut off the discovery Lively is so eager to avoid. On a final note, Lively fails to cite any authority for the notion articulated in her motion that by opposing the motion to dismiss, rather than merely amending at the first hint of criticism, plaintiffs have abrogated that well-entrenched authority that Rule 11 does not apply to the test of sufficiency of pleadings, particularly where a motion to dismiss is pending. Put another way, Lively fails to provide any support for the claim that plaintiffs are subject to Rule 11 sanctions for waiting until a ruling of their motion to dismiss to amend. This is not surprising, as there is none. Indeed, Lively's Rule 11 motion at this juncture of this litigation, which is based on issues Lively raised in her pending motion to dismiss or properly should have raised in a Rule 12b motion to dismiss, is not only premature, but entails a misuse of Rule 11. Accordingly, Lively's Rule 11 motion should be denied. Rule 11 does not apply to out-of-court statements. Although less than fully obvious, Lively appears to seek Rule 11 sanctions under plaintiffs and counsel based on allegedly harassing statements to the press. Seeking Rule 11 sanctions to deter plaintiffs' counsel and the Rule 11 plaintiffs from continuing to unlawfully harass Miss Lively with baseless accusations and statements to the press. As Lively herself explains, the central purpose of Rule 11 is to deter baseless filings in district court. Thus, Rule 11 sanctions are not available for out-of-court statements, but are confined to court filings. Plaintiffs are entitled to sanctions. This is probably my best part, okay? For the reasons set forth above and their abject failure to bring relevant authority to the court's attention, Lively and her counsel should be sanctioned in an amount sufficient to compensate plaintiffs for the time and resources expended in responding to Lively's meritless Rule 11 motion and deter any further misuse of Rule 11. Conclusion. For the foregoing reasons, plaintiffs respectfully request that the court enter an order denying Lively's motions for sanctions in its entirety and awarding sanctions sufficient to compensate the Wayfarer parties for the expense of responding to Lively's Rule 11 sanctions. Where a party's motion to Rule 11 sanctions is not well grounded in fact or law or is filed for an improper purpose, a court may find itself in the position of imposing Rule 11 sanctions on the moving party and or her attorney. Pay up, girl, because everyone knew those motions were complete BS when you filed them. And now Lively's team was quick with it. I mean, quick with it. Quick with their response to Brian Freeman yesterday, filing his motion to compel to either get the medical records or be able to, withdraw the claims. Which is it? You can't have it both ways. But Blake Lively's team was quick with it. But I'll tell you who was quicker. The judge. The judge was quick with it, and we're going to get into that in a minute. But this is the letter that Blake Lively's team filed to Judge Lehman literally right after Brian Freeman filed his letter, and it is quite entertaining. Let's just read it. On behalf of our client, Blake Lively, we respectfully oppose the motion to compel and related filings by the Wayfarer parties earlier today. The motion. Given that the motion is a false and plainly improper public relations stunt, Ms. Lively further requests that the court deny and strike the motion pursuant to its inherent power to control material on its docket that is abusive or otherwise improper under the circumstances. Ms. Lively respectfully submits that the court may wish to consider sanctions for the continued abuse of this court's docket. Girl, are you foreshadowing things that are coming your way? Because we have been reading the dockets, and somebody's been abusing them, but it ain't Wayfarer. Okay? The motion was filed for a single audience, the media. God, this excuse is getting so boring. It's so boring now. I mean, really? Brian Freeman hasn't even been talking to the media that much. Wayfarer hasn't even been putting out statements. I'll tell you who is. Who's on all those late night talk shows? Ryan Reynolds and Blake Lively? Who's running to People magazine and to the press every time something gets filed? Blake Lively's team? I mean, give me a break. This excuse is tiresome. It's like no matter what they file, no matter what they do, no matter how they defend themselves, poor victim Blake, everything's an attack. It's further harassment. It's further this. They're just doing it just for a media stunt. How about they're actually trying to save themselves and their lives and do this for themselves and their family because you've accused them of the most heinous acts. Maybe they're just trying to defend themselves, okay? There is nothing for this court to compel. As the Wayfarer parties make abundantly clear in their motion, Ms. Lively voluntarily agreed to withdraw her infliction of emotional distress claims on Friday, May 30th. Ms. Lively did so in good faith to streamline the dispute in the ordinary litigation process, given the damages she otherwise anticipates recovering. Counsel for the Wayfarer parties concede and are aware that this renders their discovery moot, but they also have been desperately searching for an angle to make a show out of Ms. Lively's decision to streamline her case. What about not providing medical records is streamlining a case? I think turning over all of the discovery and getting to it, being ready. I mean, she's been working on this since the fall, August, September, October, November, definitely December, right? Because that's when it was filed. We're in May. If it was me, I would be like, here you go. And I've been in this position. I have binders of everything. Here you go. Here's all my witness statements. Here's all my doctor's information. Here's my therapist on call, ready to answer. Here's my affidavit from my doctor. Here's all of the meetings that we had. Here's the affidavits from all of my loved ones saying how this has deeply affected me and changed me as well as them. Here's everything. Here's all of my complaints to the company. Here's every email that they've sent me ignoring thus complaints. Here's, you're trying to streamline it, are you? It's just so frustrating when you read these completely obvious lies and gaslighting statements that are really made to try to manipulate and, I think, abuse and use the court. Okay? We continue. Ms. Lively voluntarily agreed to withdraw her infliction of emotional distress claims on Friday, May 30th. Ms. Lively did so in good faith to streamline the dispute in the ordinary litigation process, giving the damages she otherwise anticipates recovering. Counsel for the Wayfarer parties concede and are aware that this renders their discovery moot, But they also have been desperately searching for an angle to make a show out of Miss Lively's decision to streamline her case. Given this, counsel for the Wayfarer parties attempted to seize on the parties' agreement as to Miss Lively's withdrawal as a basis for this frivolous motion. On Friday, counsel for the Wayfarer parties proposed a stipulation to dismiss Miss Lively's 10th and 11th causes of action for intentional and negligent infliction of emotional distress. Respectfully, Miss Lively's counsel provided proposed edits to the stipulation. Nothing major, we just did a little editing, On Sunday evening, after receiving repeated emails on Friday, late Saturday evening, and early Sunday morning. Falsely and disingenuously claiming that Miss Lively was refusing to participate in discovery by not immediately responding in the middle of the night, apparently, and threatening to advise the court. The Wayfarer parties offered no basis whatsoever for their unnecessary escalation of a mutually agreeable streamlining of claims, or why finalizing the method of dismissal could not wait until Monday morning. And they don't have to. They're fighting for their freaking lives here. They don't need to tell you nothing. They need to know, are you providing the discovery or are you withdrawing your claims? Which is it? I'm trying to work a case here. Do you know? Nonetheless, in an effort to diffuse the situation and avoid unnecessarily burdening the court, Miss Lively agreed to the stipulated dismissal and proposed modest revisions to the parties' joint stipulation for dismissal on Sunday evening. Modest. You know what the changes were? Without prejudice, meaning that she can refile these claims really whenever she feels like it. No, that's not really the way it's going to work, okay? In conveying the revisions, counsel for Miss Lively offered to meet and confer regarding any dispute as to the language of the stipulations, including on the parties' then forthcoming teleconference scheduled for Monday afternoon at 4:30. Counsel for the Wayfarer parties, including Mr. Fritz as signatory on the motion, attended the teleconference and did not address the stipulation. To be clear, at no point during the conference did they object to or raise any concern regarding Miss Lively's proposed revisions to the stipulation. Instead, they rushed to this court to file this clearly pre-written motion the minute that the teleconference was concluded. Yeah, they ran there the minute it was over. Just couldn't wait. Almost immediately thereafter, tabloid media began reporting exclusively on Miss Lively's shock move, claiming that she was sensationally dropped by her IIED claims, quoting extensively from the motion. The Wayfarer party's motion should be denied and further should be struck. It is based on two brazen false assertions. First, they claim that Miss Lively has refused to disclose medical and mental health information, but as counsel for the Wayfarer parties concede, that information is relevant only to Miss Lively's standalone tort-based emotional distress claims that she indicated she was withdrawing. So, it's just such a silly argument to say that their motion should be denied and struck, but it's based on false assertions that Blake Lively refused to disclose medical and health information. But she's only doing that because, as Wayfarer knows, she's withdrawing the claims. But guess what, sweetheart? You haven't withdrawn the claims yet, so they want to know, which is it? I mean, that is so crazy. But then to suggest that Miss Lively has refused to produce anything in connection with these claims is intentionally misleading to the court and their intended audience for this false record, the public. Second, they claim that Miss Lively has refused to properly stipulate to dismissal, but that would suggest there was any discussion or mutually known dispute as to the stipulation. As noted, there was none. Really? Further, the motion seeks to improperly compel documents that the Wayfarer parties lack a legal basis to obtain and seeks no relief at all as to the stipulation. Because the Wayfarer parties concede that Miss Lively has agreed to dismiss the 10th and 11th causes of action to which such discovery is solely directed, and they have agreed to the dismissal and proposed a joint stipulation to that effect, the motion does not legitimately seek any form of relief, is irrelevant to any motion currently pending before the court, and serves no legitimate purpose. It's a motion to compel. What do you mean it doesn't serve any purpose? As with the Friedman letter that this court previously struck, do you remember when he put in a letter and then an affidavit stating why they subpoenaed Venable, Taylor Swift's law firm for communications? They had that struck. Blake Lively's team had it struck, and Brian Freeman got a little warning that that was improper in this court's jurisdiction. So now they're saying, oh, well, just like that letter, this one is too. The apparent intent of the motion is to launder their public relations narrative into the press by abusing the court's docket. Ms. Lively respectfully requests that the court exercise its inherent authority to control its own docket and strike the motion unnecessary, improper, and abusive. The court may also wish to issue sanctions under its inherent authority to deter continuing misconduct in connection with the Wayfarer party's future filings, as this court has warned against. Last, because the parties have agreed to dismiss Ms. Lively's 10th and 11th cause of action, Ms. Lively requests that the court exercise its inherent authority and authority under Rule 15 to dismiss them without prejudice. She's like, please, Judge Lyman, please, 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 Daddy, I'm Blake Lively. You have to do whatever I say. Please. They're not playing nice with me, so can you do it? Ugh, gross. But it's okay because you know what? The judge already responded. He already came back the next day. And his response is, and I quote, "The motion to compel at docket numbers 261 and 262 is denied based on plaintiff's representation that the relevant claims will be withdrawn. Lively's request that, because the parties have agreed to dismiss Ms. Lively's 10th and 11th causes of action, the court exercise its inherent authority and authority under Rule 15 to dismiss them without prejudice, is denied without prejudice to renewal. The parties shall stipulate to whether the dismissal is with or without prejudice, or Lively shall renew her request by formal motion. For avoidance of doubt, if the claims are not dismissed, the court will preclude Lively from offering any evidence of emotional distress." So let's just go over exactly what this statement means. In my opinion, of course. First off, I love that the judge just totally skipped past all of their BS and the same lies and the same thing that they've been saying. Oh, they're abusing the court, have sanctions. They're only doing this to further harass Lively. They're just doing this as a publicity stunt, da-da-da-da-da. He didn't even address all of that, which I like because it's complete BS. And think of something else, because how many times now has Lively's parties gone to the media? I mean, Lively herself has set up on late night talk shows at the Time 100. Give me please, we all see it. We all see the show. She's running around here acting like everything is totally fine. Her and her husband, la-di-da-di-da-di-da-di, we're untouchable. It's it's gross. But basically he's saying that this letter that was just filed is going to be denied. So what he's asking for is denied. He's not personally going to make any ruling on this motion. What he's saying is the parties still haven't conferred. They need to come up with a resolution themselves. Blake Lively's team pretty much asked the judge to step forward and let her withdraw these motions without prejudice. That's basically what she's asking. She had asked the judge, can you step forward under Rule 15 and dismiss them without prejudice? I'm going to be withdrawing. Can you do that? And the judge pretty much is like, whoa, I'm not touching this yet. Y'all just need to figure it out by yourselves, confer with each other first, and really try to work it out before the court steps in. Now, if they go back to the table and they try with prejudice, without prejudice, withdrawing, not withdrawing, da-da-da-da-da-da, what he's saying is then you can file a motion to have it withdrawn without prejudice. However, the Wayfarer people will be able to argue that motion. And if you're leaving it up to me to decide, I may or may not go in your way. However, y'all need to work it out by yourselves. Something interesting that he did say at the very end of that, though, after saying yo, work it out for yourselves. I'm not getting involved. I'm not stepping in. However, if you want me to step in, you need to renew your request with a formal motion. Pretty much just letting them know that if you do that, okay, but it needs to be a formal motion. I'm not taking all of this in. But then he says at the very end, for avoidance of doubt, if the claims are not dismissed, the court will preclude Lively from offering any evidence of emotional distress. And I think he's just giving her a warning like, hey, now that you've introduced this and saying that you are going to withdraw these claims, either you have to withdraw them and you can't bring any evidence or mention them again in court, or you need to provide your medical records and keep them in. But either way, if you don't actually get rid of these claims, you can't try to argue emotional distress related to them or introduce evidence about it later on because you're withdrawing the claims. And now we already know that you have voluntarily offered to do so. And also something of importance of note is that I also think that what they're saying is like, hey, now if you don't actually dismiss the claims that you claim that you are dismissing by holding up discovery, not providing your medical records because you are going to withdraw these claims, if you don't actually dismiss these claims or they don't get dismissed and you withdraw them, you're not going to be allowed to provide any evidence of emotional distress that's related to them. So Blake Lively and her team they're pretty backed into a corner here. It's going to be very interesting to see what happens next. I don't know. What do y'all think? I just think at this point, maybe Blake Lively should just settle with a public apology and claim temporary insanity, because it's the only thing that will explain what the heck is going on and what has happened here. Because if this happened to you, if this really happened to you, show the evidence. Prove your case. The medical records will always strengthen your case if infliction of emotion was actually caused. There is no way you come out of this to what she's claiming, to the degree of what she's claiming in her claim, without leaning on someone, whether that's your doctor, your therapist, and a natural whatever pissed, your friends, your family. Do you know where's all your stuff? Weren't you ready? Weren't you ready to fight? Weren't you ready to stand up and speak for all women to ensure that future victims and survivors, have it better and this doesn't happen to more women? Weren't you ready for this fight? So then why aren't you fighting? What is in those medical records that you don't want anybody to see? At this point, just claim temporary insanity due to postpartum and narcissistic behavior and being a complete sociopath, I don't know, in an abusive relationship. What else? What could the alternative be? Well, that's it for me today. I'm gonna go and enjoy the rest of this beautiful day. The sun is shining. It's so gorgeous. Hence, the little summer dress finally. It's so nice. I hope you enjoy the rest of your day. And yeah, drop all your comments and let me know what you guys think about this, because I feel like this week is gonna get bananas. Okay. So I'm here for it, and I will always keep you updated on the latest with It Ends With Never. But go out, enjoy your day, enjoy the sunshine if you can, and I'll talk to you soon. Love you. Bye.